As everyone knows, House Bill 1228 is now on my desk, and it's time for me to take a look at it and make some comments in reference to it. This is a bill that in ordinary times would not be controversial, but these are not ordinary times. This bill is not really complicated. The bill itself restates the standard of review for the courts to consider in determining First Amendment privileges as weighed against the compelling interest of the state. That's simply stated as a summary as to what this legislation does. It's a balancing test. The bill itself does not pick winners and losers. It balances two competing constitutional obligations that our founding fathers gave to us. But the issue has become divisive because our nation remains split on how to balance the diversity of our culture with the traditions and firmly held religious convictions. It has divided families, and there is clearly a generational gap on this issue. My son Seth signed the petition asking me, Dad, the governor, to veto this bill. And he gave me permission to make that reference. And it shows that families, and there's a generational difference of opinion on these issues. So where are we now in reference to this legislation? I have asked through this process of our legislative leaders and members that certain changes be made. In some instances, they were accommodated and changed. In other instances, they said no. And that's the balance between the executive and the legislative branch. I certainly respect those bodies. It's been my intention all along that House Bill 1228, the Religious Freedom Restoration Act, be crafted in a way that mirrors the Federal Religious Freedom and Restoration Act that was passed in 1993 and was signed by President Clinton. I came to Congress after that, but I sat on the Judiciary Committee in the House of Representatives that considered these amendments, had hearings on this Federal Religious Freedom and Restoration Act, and so I'm somewhat familiar with it and how it's played out across the country. And it was my intention, because the federal law does not cover state causes of action, that we have a similar law in Arkansas. And but we wanted to have it crafted similar to what is at the federal level. And to do that, though, changes need to be made. The bill that is on my desk at the present time does not precisely mirror the federal law. It doesn't mirror it in a couple of ways, particularly allowing the First Amendment to be asserted in the private litigation between parties or the reliance upon the state law and those claims. Therefore, I asked that changes to be made in the legislation. And I've asked that the leaders of the General Assembly to recall the bill so that it can be amended to reflect the terms of the Federal Religious Freedom and Restoration Act. In the alternative, it can be simply have some language changes so that those accommodations and changes can be made. So it can either be done by recalling the legislation or having additional legislation that would accomplish those changes. Again, this is difference between the executive branch, the legislative branch. We all have our responsibilities. We all have our different viewpoints. My responsibility is to speak out on my own convictions and to do what I can as governor to make sure this bill reflects the values of the people of Arkansas, protects those of religious conscience, but also minimizes the chance of discrimination in the workplace and in the public environment. It is important to recognize that the bill, even as currently drafted, does not change who we are. And it does not change the current protections against discrimination. This bill simply defines a standard to determine the right balance. but how do we as a state communicate to the world that we are respectful of a diverse workplace, and we want to be known as a state that does not discriminate but understands tolerance. That is the challenge that we face. Making this law like the federal law will aid us in that effort in communication, but also it was my original objective from the beginning. Another option is that we're looking at is to utilize an executive order, which interestingly has not been utilized from my research from the executive branch in state government in terms of protecting against discrimination in the workplace for state government. But we're looking at an executive order to aid in that communication and to make it clear that Arkansas wants to be a place of tolerance. We want to be a place that has the right balance between religious protections and religious freedom and non-discrimination. Also, I think we can be assured that this will continue to be a robust debate in the future. I understand that a ballot title has been approved by the Attorney General that may put on the ballot an extension of the civil rights protection to additional classes of citizens of Arkansas. That debate will continue and ultimately be determined by the people of this state, either through their legislative body or through a vote of the people. And so this conversation does not end. I've expressed my view to the legislature. It is up to them to respond to the request of the governor that changes be made in the current bill to make it reflect the federal law that I think sets the right tone for Arkansas in its future. We'll look at additional action down the road as needed, partly depending upon the action that the legislature might take.